Advertising Council Australia would like to begin by acknowledging and paying our respects to the Gadigal people of the Eora Nation, who are the traditional custodians of the land from which we broadcast today. ACA would also like to acknowledge their culture of storytelling through art, dance and music, and we pay respect to the elders past, present and future on other lands throughout all communities who might be participating today.
Everybody, I'm Hannah Sturrock, National Head of Engagement at ACA. I'd like to welcome you all and say thank you for creating space in your diaries to attend this briefing on sexual harassment in the workplace. We are recording the session and it will be available to ACA members in the next day or two. So just a quick preamble just to provide a little bit of context. We launched Create Space a year ago, receiving over 2,600 responses to the first ever industry census. We then published the Create Space report and phase 1 action plan in July. If you haven't yet watched the launch webinar and downloaded the report, I have an actual printed copy here today. I encourage you to do so to get the full picture of where the pressure points are and ensure your business is doing its bit to drive progress. Our first call to action was to tackle gender inequity and improve the experience and representation of female talent. The big stat from the census was that 1 in 4 mid-career females are likely to leave the industry due to a lack of inclusion or discrimination experienced, and 8% of female respondents had experienced sexual harassment at work in the last 12 months, but less than 30% of those people reported it. This informed the first step in the action plan, tackle sexual harassment and victimisation by downloading and adopting the Create Safe Space Toolkit and 6-step plan, a combination of templates, resources and training to tackle this issue systematically. That's all available at createspace.org.au. Resources and training are critical, but the fact is the only thing that prevents sexual harassment and bullying is a company culture that simply doesn't tolerate it. The most effective interventions involve visible and committed senior leaders who set the tone for cultural change, which is why it is so great to see so many of you joining us today. Create Space is an ongoing program to design and deliver valuable data, resources, training, and partnerships to focus and support our members and the broader industry on their journey towards diversity, equity, and inclusion, which brings me to our new partnership with Danny King Legal, a team of employment and industrial relations lawyers representing employers, employees, HR professionals, and other lawyers. They were named Australasian Lawyers Top Boutique Firm 2022 by Employment Law Australia. Principal Danny King has been recognised in the Doyle's Guide consecutively from 2015 to 2022 as a preeminent lawyer in employment and industrial relations. And DKL was named Boutique Diversity Firm of the Year at the Women in Law Awards last year. So I'm really glad to introduce you all to Dimitrious Havadjia, a solicitor at DKL, who is going to take you through the briefing. And it's very relevant given the Respect at Work bill has passed the Senate this week. And we will hopefully have some time to answer questions at the end. So please use the Q&A box during the session and we'll get to those at the end. And we'll also send out a fact sheet afterwards to all registered attendees. So with that, I'll hand over to Dimitrious.
Fantastic. Thank you for that introduction, Hannah, and it's great to be here with everyone. We do have a lot to cover today, but as Hannah said, put your questions in the Q&A, and if we don't have time to get to all of them included in that mail out, I'll have a look at them and we'll send through questions that we've missed that we think we might be able to help you get some clarity on. So I will bring the slides up for everyone now. Fantastic. All right. So as Hannah said, thank you for that introduction. This is incredibly relevant. We've just had the passing of the Respect at Work bill on Monday, and so that's going to be dropping into the legislation any day now. And so what we're going to cover today is a range of different topics related to sexual harassment, talk a little bit about what does it mean, particularly in an employment and employee context, Then we're going to talk about what it actually looks like, because I know a lot of clients come to us asking, what does it mean? Is this sexual harassment? Is that sexual harassment? And go through some examples. We're going to talk about why employers have obligations and how those obligations are changing. And that's a big area of focus with the reforms that have come through this week. And then lastly, talk about risks and the avenues that employees have if these issues can't be managed internally within the organisation. So before we get started any further, we just want to flag that this is obviously a sexual harassment presentation. Hopefully everyone knows that by now. But we are going to talk about things like sexual harassment, and there is going to be some, examples of that kind of conduct in here. So we just want to make sure we're all being really respectful. But that said, if there is something that you're unsure about, don't be afraid to ask. The only bad questions are the ones that don't get asked. So feel free to ask away, but we just want to flag in advance we are talking about what can be quite a sensitive issue. And the reason for that we're going to talk about in a second. But before we get into it, we want to prime everyone with a little bit of an example. This is an excellent video that we use in our training sessions. It's been done by the BBC that runs through a kind of classic interaction between two co-workers and how that might become inappropriate. And that is something we want to be cautious of. Some of the examples in this might be really obvious, but I encourage you to think about what we're going to show in this very short video and see if you can find the examples of what might be sexual harassment, and just reflect on that as we go through the presentation today. And maybe what you thought was appropriate at the start might be inappropriate, or vice versa as we walk through. So I'm going to start this one now. And yeah, keep your thinking hats on for looking at what might be inappropriate conduct.
You must be Kat.
Yes.
Nice perfume. Stock order's done.
But I was just coming back to finish it.
Ah, teamwork, innit? Brains and beauty. See ya. Now, these staff nights are important. Being a team, having a laugh.
Cheers.
One drink. You look like you need it.
I should get going.
I'll get you a taxi.
No, it's fine.
No, I've got it. And I'll carry it on. What's your address?
All right.
Thank you.
Oh, you're not taking that on home?
I forgot to split it. Doesn't matter. I'll book another. Unless.
Sorry.
No, I'm sorry. I thought I was getting signals. Are we okay?
Yeah, of course. I just need to get in. See ya.
All right, so I can appreciate that example is not exactly aligned with what is likely to be experienced with everyone here today. But you will note, for example, that some of that stuff happened outside of work and at work functions. And they're the kind of things we get a lot of questions about. So we're going to talk about them a bit later. But adding on to the statistics that Hannah has brought to us, these ones are from the Respect at Work report, which was published in 2020. You may have missed it because there were lots of other things happening in 2020 that were distracting our attention. But what it found is in the past 5 years, 1 in 3 people had experienced sexual harassment in work, in a work environment. And that was an increase on the previous 2 surveys that they had done, and a double-digit increase in the amount of people who had been affected. So that is something which is quite considerable, and it's why it's important to be considerate when we discuss these issues, because it's highly likely that someone on this webinar today, just statistically, has had personal experience with sexual harassment at work. But equally, it's not just a one gender or another identity issue. As you can see, these statistics tell us that 2 in 5 women have experienced sexual harassment, but also 1 in 4 men. So it's really important that we are being considerate of everyone and not making assumptions about the kind of people who are going to be affected or aren't going to be affected. And that's a problem that we've had with several clients where, because they don't fit the stereotype, they haven't been taken seriously by their employers when they've raised concerns. And that's something we want to avoid. So awareness is key here in making sure that we avoid this kind of problems. But now let's talk a little bit about what sexual harassment is from an employment law and employment perspective, noting that we're not covering on the criminal aspects of that today. That is separate legislation and it's a separate scheme, and it does have a slightly different definition of what counts as sexual harassment. But for our purposes and for the purposes of the Respect at Work Act, which has just been amended, what is sexual harassment in the workplace? We can look to the Sex Discrimination Act 1984 and to Section 28A. The definition there is up on the screen, but essentially there's three parts. The first is that a person has to make an unwelcome sexual advance or an unwelcome conduct of a sexual nature. That's the first part. The second part is that a reasonable person in all the circumstances might have anticipated the possibility. That is the second part. And the third part is that they anticipated the possibility that person would be offended, humiliated, or intimidated. And so there's kind of three different things we need to be thinking about when we're thinking about what sexual harassment in a work context might look like. It's whether the conduct was unwelcome, whether a reasonable person in that scenario then would have felt that the person who was the subject of that would have been offended, humiliated, or intimidated. The reason we reference the Commonwealth legislation is it does apply to everyone. But each state does have a similar anti-discrimination regime, which includes wording to the same effect. So regardless of where you are, this is the kind of definition you're going to be looking at and you need to be considering all across Australia. So a question we often get asked by clients, and we've actually got a matter at the moment where the clients are asking that is, but the Act doesn't say anything about employees. When is it something that employees have to care about? Surely they can't be responsible for their, the actions of their employees all the time. The question is, though, is whether it's in connection with employment and in connection with work. And the courts and the legislation is very broad in that aspect. So what it tells us is it's both in the workplace, which is the obvious example. It's when we're working from home and even, those kind of interactions via Zoom, but it's also any work-related activities. So that includes the much maligned Christmas party, but also courses, conference, training events, anything like that can be counted as work. There was a case about 10 years ago where there was a sexual assault that happened between two employees at the hotel at the end of a week-long conference. So on the Friday night, and the conference finished on the Friday. The court found the employer was responsible for that and was liable because the only reasons the employees were at that hotel was because of the work conference that week that they'd been attending. So even though the conference was over, the employer was still found to be liable. So it's really important that we cast a broad net and think about it in that case. And particularly, I know for everyone who's attending today, it doesn't just mean employee behavior. It can be sexual harassment from an employee to a client, from a client or to an employee. It can be between a third party, a referrer, a marketing advisor, any of those kind of people. And so if they're captured in that kind of work, if someone in that interaction is related to work, they're very likely to be captured by this legislation. And so it's really important that we're conscious of all the individuals that we're interacting with, and we put steps and systems in place to resolve those kind of issues early. So it really doesn't matter whether it is your account manager or your creatives or your CEO, all those people are going to get roped in, and so are clients. So this is the classic that we hear, but I didn't mean it, it was a joke. And the question we often get asked is, can you still have fun in the office? Does this mean the death of the Christmas party or Friday night drinks? The answer is no. Jokes are still allowed, that's totally fine. But we note the definition means the conduct has to be unwelcome for it to be sexual harassment. So if everyone is a willing participant and everyone's in on the joke, no worries, everyone's sweet. But the problem is we can't rely on the person who's saying it or doing the action's intention. That's not relevant. What we need to think about is how a person receiving that joke or that comment or that interaction is going to feel. And that is what turns something from fun into harassment. So we really want to keep that in mind because I think often things can be misinterpreted. And that is where there is issues because we don't think about other people's experience and how they might not take something as a joke that we think is really obvious. So that's why it's important to be conscious of that. And it doesn't mean, we can't have fun in the office, but we just need to be conscious of maybe the open plan office, in front of all the new junior account managers, maybe we don't make a comment about what we did last night in front of them. It's just those kind of things. We want to be considerate and think about the context. So some examples then of what it looks like. Sexual harassment can be single or repeated event. So that's different from what you might be aware of with bullying, which does need to be repeated conduct that creates a risk to workplace health and safety. So one instance of an inappropriate comment or a touch in the wrong place can be sexual harassment under the legislation. Legislation doesn't really tell us what it is, But the cases and also the guidance from the Respect at Work report provide a very long list, as you can see appearing on the screen, of the kind of things which can be sexual harassment. Particularly one in the current age, things like asking intrusive questions about a person's private life or body is one that is potentially a bit new to people in the age of differing gender identities. Asking questions about what private parts do you have can be sexual harassment, and it's not appropriate if it's unwelcome. So very broad. In the same way that things that are connected with your workplace are broad, it's equally broad when we're thinking about the kind of conduct that may be sexual harassment in all the circumstances. This is a great example. It's one of my favorite examples. Is this poster sexual harassment? Lots of people have said, when we've done these training sessions, oh, maybe feels a bit funny, but surely it's just a joke. And the courts in New South Wales said yes. And the case was brought by the woman who is in the actual photo there with her hands up. And the context was that she was asked to participate in this campaign for Safe Spine. They took some photos of her, but they never told her how it was going to be used. And then she came to work one day and someone showed her a picture of this poster in the men's bathrooms. So she successfully sued her employer for sexual harassment and was awarded $200,000 in damages. So $100,000 from Sydney Water, who was her employer, and $100,000 from Vitality Works, who was the marketing company that was commissioned to do this. So something to think about when you're acting, from an advertising perspective is even if your client gives you instructions that cause sexual harassment to occur, there is potential for that to be something that you could be also on the hook for, depending on the level of engagement with that. So it's even sometimes accepting instructions from a client or a prospective client could be something you need to be aware of in terms of not falling foul of your obligations regarding sexual harassment. The even more, I think, terrifying thing about this case is that the court actually said that she was entitled to about $330,000 worth of damages, but because there are caps in New South Wales, you can only get $100,000 per person that you sue. So $100,000 from Sydney Water and $100,000 from Vitality Works. But yeah, it's a lot of money for what was probably, everyone thought, a fun little joke. And I can assure you that Vitality Works will not be making posters like that anytime in the future. So something to keep in mind, what can seem very innocent can be very, very expensive. And that's something we want to think about when we're thinking about sexual harassment. I think it's often quite well known the impacts it can have on an individual, but it's also got massive impacts on your business. And that's especially in the current age where if this kind of thing gets out in the market that's post-COVID, where it's very hard to hire employees, certainly in law, and I imagine it's quite similar in this industry as well. Having a reputation as a firm that doesn't act on sexual harassment, that has those kind of people inside of it, it's going to make it very hard to recruit and very hard to keep people once they're in. So not only have you got the risks of being slapped with, a lawsuit, as was the case we just talked about, but there's also just the cultural and internal experiences that people are going to have. They're going to make them less productive and they're going to make them less likely to commit to your business long term. So there are, business benefits, return on investment for doing things like reducing sexual harassment and creating a good culture. Let's then talk to the employer obligations. This is what clients come to us a lot about to understand, well, I don't really understand, the account manager is the one who has sexually harassed the senior account manager. Why is the employer involved? It's between two individuals. It was an after work drinks. Why is it our problem? Legislation thought about that, and they wanted to make sure that prevention of sexual harassment was a two-way street. So both that individuals and companies had an obligation to do something. And so the legal concept behind that is vicarious liability. And what that means is that the employer will be held responsible for acts of sexual harassment committed by employees unless they have discharged that liability by taking all reasonable steps to prevent sexual harassment, which is about to change, but we'll talk about that on the next slide. The courts have not been very useful. The legislation is not very useful when talking about all reasonable steps. So the courts have jumped in and told us, well, this is what employers who want to be best practice have to do to make sure they're not going to be on the hook for any sexual harassment done by their employees. And they say you need to have a sexual harassment policy and implement it and monitor its effectiveness. So it can't just be a one-liner. It can't just sit on the shelf in the bottom of the HR's desk. It does need to be something which is reviewed often, which is detailed and explains to people what they can and can't do. They need to provide training on all the policies and harassment for staff. So these kind of presentations, doing those to your employees is going to be something which is going to be seen favorably in terms of discharging that obligation, but also making sure people understand what it means. So it's not just enough to sit them in front of a video, but make sure you're engaging with them and, querying them on whether they understand what is appropriate and what isn't. And lastly, making sure you actually do something about sexual harassment if it happens. If you're doing things like burying complaints or not investigating them or giving people repeated slaps on the wrist, it's not proportionate to what's happened, that's not going to be considered all reasonable steps. So the bar was already quite high for employers, and almost all the cases said that the employer had not done enough and therefore they were held to be liable. With one notable exception we'll talk about in a minute. Changes here. As we talked about this week, the legislation as part of the Respect at Work bill passed, and that means that all reasonable steps will soon no longer be a thing, and instead employers are going to have a positive duty to prevent sexual harassment. What does that mean, you ask? Well, we're actually not sure yet because it's only just been released and there's no cases on it. But the notes say, and the explanation given in the legislation, is that it's similar to the obligations that employers have regarding workplace health and safety. So that means you have to be proactive about addressing things and issues like sexual harassment, proactive about reducing risk, and proactive about acting on things when they come to your attention. So it's certainly not something which is going to be easier to discharge, but absolutely the intention is to make it more onerous for employers to comply with this, which I know is painful, but that's why people like DKL are here to support employers through that change. The next thing is that's quite new in this space is the Australian Human Rights Commission will have the power to, of its own accord, do investigations and audits. So they can rock up to your office and say, yeah, I'd like to speak to the managing director about how they are complying with their positive duty to prevent sexual harassment. Thank you. Which is a bit terrifying, but it's similar to what the Fair Work Ombudsman can do with regards to underpayments and that kind of thing. And I think particularly the Australian Human Rights Commission is likely to do this if there's a series of complaints that have been made. They can now have the power to say, we've got 3 complaints from the same employer in the last couple of years. I think we need to go and see what's going on. So that's something to be conscious of. There is external eyes that might be coming down to watch. And the last thing is that now creating a hostile work environment is a distinct prohibition. What does that mean? It means previously it was kind of in the legislation that, potentially someone who's sitting in the open plan office and, hears a comment made by the senior creative, but isn't actually part of their team, can make a claim, but it was quite difficult because you had to prove that kind of connection. Now, if you've just got an environment where people are saying things or doing things which might be sexual harassment, even if there's not a specific person who's being targeted by that conduct. So I know the classic one is like, the nudie calendar in the bathrooms. Those are the kind of things which they're targeting by this change and are now going to be distinctly prohibited. So you really want to be careful, again, what you're saying around others, because even if it's not targeted at a specific individual, it may still be sexual harassment that can be actioned underneath the changes to the legislation. I'm going to be really cautious about that. And that's something which we've seen quite a lot from our clients where, there's nothing that's happening specifically to individuals, but just comments get made, at the lunchroom or whatever, which make people feel uncomfortable. So lots of things that employers need to do. Sounds pretty scary, but there are a couple of things you can do to be best practice and avoid falling foul of these kind of issues. First thing you want to do is create a safe working space. And that involves things like making people feel comfortable they can speak up if something happens and giving people, that flexibility if they need it and just being there for people when they have problems. Next thing is providing information and training, which you've kind of already touched on, but you do want to make sure you're providing that in a way that's specific, that's targeted, and is something which you're checking people actually understand. And a lot of people, as was evidenced by the discussion we had earlier regarding jokes, just aren't aware of what the legislation actually says is inappropriate and don't necessarily consider people with other lived experience and how they might interact or experience things like that might be a joke to me isn't necessarily going to be a joke to other people on this call. The next thing is to address unwanted or offensive behavior early. That's being proactive. That is, managing from best practice, leading by example. And then the last thing is obviously you want to encourage people to report. And so that way people feel like if something unfortunately does happen, as much as we would like to, it's impossible to control every single part of our employees. So it is important to have systems in place when things do go wrong, but making sure they're effective, making sure everyone understands them, making sure they're confidential and they respect all the parties involved. It's going to go a long way to making sure you've got a workplace which holistically is doing the right things, has all the benefits I already talked about, from retention, from messaging, from, you know, not having legal suits thrown at you, but also means that you're protecting yourself from anything that the Australian Human Rights Commission might want to poke around and have a look at. So the other thing that we get asked by clients, particularly in management, is like, does it really matter? Like, you know, again, if the business is going to subsume the liability because of vicarious liability, what incentive do individuals have to change their behavior? It's their boss's job to care about this stuff, not them. That is incorrect. Even though employees will be held liable, in addition, it will always be in addition to that individual. So individuals will also be named in an application that's made, and they will be personally held liable for sexual harassment. So that means the court can make individuals pay the damages. And so in the case that you can see there on the screen, $450,000 was required to be paid by the specific person who did the sexual harassment, and actually $0 had to be paid by the employer. And it was a rare case where the court said, look, the employer actually did have good policies. They did have good systems. They did have good training. And this person, of their own accord, essentially date raped this individual. So that employer was found not to be liable in that circumstance. And that was something where, you know, rarely the employer got off the hook, but the employee absolutely had to stump up for that amount of money. So it can affect you as the individual who's doing those actions. You can also be fired. There's an explicit carve out for unfair dismissal that says dismissal based on sexual harassment is not unfair. So you really need to consider your employment future as well. Sexual harassment can be criminal conduct. As I said, not covered by this seminar, but they do run in parallel. So you can have the police doing their own separate investigation and be found guilty of a crime, and equally have someone making a complaint via the Australian Human Rights Commission process, for example, and getting financial compensation from that person. So you can, if you are found guilty of this kind of conduct, be fighting a battle on two fronts. It can be very serious and also incredibly expensive. The last thing, particularly for management to be aware of, is that there's also a specific prohibition for aiding or permitting sexual harassment. And what that means is if you are found to have known about something, seen it happen and not said anything, if you're bearing allegations or not investigating them properly, you can be found accessorial liability, have accessorial liability. And what that means is you will be seen to be just as bad as the person who did the conduct themselves. So this is the big red flashing alarm for people in management and people in HR. You really want to be thinking about, if you have knowledge of something and you don't act and it goes to litigation, you'll be also on the hook for potentially paying those $450,000 settlements if they get that far. So this is everyone's problem. Employers need to be taking steps, employees need to be taking steps, and management needs to be taking steps, because everyone can get roped in. And that is the specific intent of the legislation. They want to make sure everyone is doing the right thing and reducing sexual harassment in the workplace. Very, very serious stuff. Don't mean it to sound like super scary, but it can be quite confronting when people realize the amount of power that this legislation can have and the amount that it can actually do to a business and individuals. So talking of what they are then, if you can't manage things internally, so if the employee affected or the client affected or the supplier affected is not satisfied with the internal responses that they get from an organization, there are some legal avenues that they can take that will escalate into those claims that we've talked about for $450,000 of damages. There's 4 key ones. We're not going to go into all of them in this seminar because that will depend on the specific fact scenario as to which one's going to be most appropriate. But all of them have burdens on business and are painful to deal with. Even the least ones, for example, the Fair Work Stop Sexual Harassment orders, where there's no compensation that is needed to be paid by an employer, is still very painful. You have to rock up to the Fair Work Commission. There's submissions of evidence. You have to talk about why it's what you're doing and why it's sexual harassment and the steps the employer is taking. And the Fair Work Commission, while they can't make you pay money, can make you do things like order retraining, build a separate office to put that individual in so they can't sexually harass others. Do undertakings to ensure that management teams get changed so that, the CEO is not reporting to the CFO, for example, which is ludicrous from a business perspective, but it's within the power of the Fair Work Commission to ask businesses to do that. So even though you're not going to have to pay for it in monetary compensation, the logistics of trying to comply with the orders made by the Fair Work Commission can cause a whole lot of headaches, and you really don't want to go down that path if you don't have to. Fair Work General Protections is designed in circumstances which unfortunately we see quite frequently, an employee is sexually harassed, they make a complaint to their employer, and then they get terminated. And that would be where they would use the General Protections route. That has got a 21-day deadline from the dismissal, and then they can do they get damages and potentially penalties for breach of the Fair Work Act. The Australian Human Rights Commission is probably the most common one in this circumstance. And that's when you've got 24 months from the event. So the person doesn't have to be an employee anymore, but as long as they're within that 24-month time frame, they can make a complaint. And assuming you go all the way through that process, you can get damages and compensation. So for example, that $450,000 case, that was done via the Australian Human Rights Commission process. That has just changed. Previously, this process was a cost jurisdiction, which means that whoever wins the case gets their legal fees paid, broadly speaking. That's just been changed so it's similar to fair work litigation, which means each party pays their own costs, regardless of who wins. The intention of that by the legislation was to make it easier for people to make these kind of complaints, because they don't have the fear that if they lose, they're going to have to pay not only their own legal fees, but the employer's legal fees as well. So it's likely to result in an increase of complaints to the Australian Human Rights Commission, because it's now a bit easier to do that from a financial perspective. Lastly, in terms of state anti-discrimination, again, it's a similar process to the Australian one. It's just state-based. You've got 12 months from the sexual harassment event, but again, you don't have to be an employee any longer just to make that claim. And lastly, they can get damages and costs. So that is one where the winner does get their fees paid, but it is capped. So as we talked about earlier in New South Wales, it's a $100,000 cap on the amount of damages. In WA, it's $40,000, which is a lot less, which is why when we work for employees, we often tell them to use the Australian Human Rights Commission, because there's no cap there. They can get as much damages as the court deems appropriate in the circumstances. So it's quite a lot of options. And importantly, as we've already kind of talked about, it's not just options for employees, but also other people that you're interacting with, your suppliers and your clients, who can make claims against you under a lot of these mechanisms. So what can we do at Danny King Legal to help you out? A couple of different things you can think about. First thing is what we help employers with is sexual harassment audits and training. So we essentially do a bit of a health check of what you've got there and give you a report card on what needs to be improved. And we do a longer version of this seminar with your employees so that they can understand the risks, and what they need to do to make sure they're not committing sexual harassment, and also talk about the processes the business has in place in order to prevent that. We also do a similar one for discrimination and bullying, which unfortunately is often hand in hand with sexual harassment. They are separate issues in terms of looking at it from a legal perspective, but we often find clients who have a sexual harassment claim also have a bullying and discrimination claim. So it's something you can tackle together, but also can be quite distinct when talked about from a risk perspective. Last one is contracts and policy creation. So that is kind of getting on the front foot. Having a clear policy is going to be one thing which not only fulfills the obligations from a positive duty aspect, but also just means you're setting expectations up front. When people start with you, they know what to expect, they know what the standard is, and they know who to talk to if they've got questions about what's happening to them and what's happening to those around them. That can be a really good way to kind of head off people who might be, someone prone to making a mistake that can cause them a lot of problems, but also, again, is a really effective way when you're doing things like onboarding and even having contracts that reflect those kind of things, can really send that message quite clearly from the start of the employment of what the kind of employer you want to be and how you're going to respond to these incidents if they occur. And the last thing we do is we can do kind of crisis management, help you respond to complaints and make sure you run that process properly. Because, for example, even though it is true that sexual harassment sexual harassment occurring with an employee does give rise to an employer's ability to terminate, there are still things you need to be conscious of before you just go off and fire that person, in order to make sure you're not getting kind of like a double claim where the person who has been sexually harassed is claiming against you, but also the person who is the harasser is claiming against you for the way they were treated in that process. We currently have a matter where that's happening, and I can tell you it is very messy because everyone is upset. And so it's really important to make sure you get in early to get advice when something does go wrong, as soon as you feel like the wheels are starting to fall off. And the way we can help you do that at Danny King Legal is because of your membership. There are a couple of specials that we provide to you guys that the general public doesn't get access to. So you get 10% off our sexual harassment training packages, which is what I talked about earlier, 20% off our contracts package if you want us to come in and either have a look at or redraft your employment contracts. There's also access to a free 30-minute initial consultation with the team, and that can be about sexual harassment, it can be about an employee who's underperforming, whatever it is you need support with. And lastly, as was kind of alluded to by Hannah, there are going to be a bunch more fact sheets launching on the ACA members page on the website. And that's going to have, again, information not just about sexual harassment, what we've covered today, but also a lot about other issues, employment of contracts, awards, overtime, all that kind of thing. And that's going to be free for everyone to access. And there'll be a link to a bunch of resources there too. So that will hopefully be coming in the new year so that we can make good decisions to protect our businesses, because as much as you want to do the right thing and as much as you can have great policies in place, we can't control every aspect of employees, and inevitably things will go wrong. What you can do though is set up systems, set up processes, and set up documents that mean when things do go wrong, you have a clear process to follow and you can protect yourself from any liability moving forward. So we've sped through that one. People are going to have some of their afternoon back, I think, Hannah, but let's go do some questions if you like.
Yeah, wow, cool. That was, it was intense, but I hope informative, and certainly gives everyone a sense that they know kind of what the lay of the land is as of right now, both from an employer directly being liable, but also that accessorial liability, which I think is a really important thing to consider. We have got a couple of questions that I think you will be able to answer. One is, if someone has a complaint and it's deemed adequately dealt with and addressed internally by all parties, can the complainant still sort of come back and make a claim separately to the process?
Absolutely. Unless as part of that resolution, there's some kind of deed of release signed where that person who made the complaint is, waiving their rights into the future, that person is still very able to make a complaint, even if everyone thinks everything's fine. Obviously, there are risks to that. If you're an employee who's told everyone that it's, yeah, thank you, I'm really content, and you go off and sue them, it's probably not going to be good for the employment relationship. It's going to make things very uncomfortable. But from a risk and liability perspective, absolutely, there is still, as long as it's within that time frame, for example, for the federal body of that 24 months, there is still a risk there that a claim can be made. So yeah, unfortunately, even best process internally is not like a get out of jail free card in this instance.
Great, thank you. And then around this idea of where there's no direct target for a comment. So when there are comments of people feeling uncomfortable around the office, but no formal complaint is made, what is the role of the employer in this situation? I'm guessing this goes to the sort of the proactive piece rather than the reactive piece.
Yeah, so I think this question might have been totally different if the Respect at Work legislation hadn't passed this week, because I think the obligation was slightly less, but I think now there's a positive duty on employers, even if there's no formal complaint made or informal complaint made at all. If you're seeing things which your spidey senses are telling you, from seeing this webinar, that sounds like it could be sexual harassment, and you're not doing something about it, absolutely there's liability there. The question is always going to be, if no one's there to make it, if a tree falls in the forest and no one's there to hear it, if no one's there to make a complaint, what's the realistic liability of risk? And that will be a question of, A, you never know when someone's going to make a complaint, but B, with the new powers of the Australian Human Rights Commission, who knows when they're going to come knocking at your door to find out what's going on. So yeah, I think now, particularly with those changes, if you're seeing things that might make people uncomfortable, you really do need to be proactive.
Yeah, just get on the front foot, run the training, really tackle it head on kind of thing.
Yep, absolutely.
Another question we have is, what responsibility does a business have if a claim is submitted against an employee that is no longer actually employed within the business? An ex-employee, I guess.
Excellent question. So if it's made just against that employee who's no longer with the business, and that person who's making the complaint or the application hasn't named the employer, then great. But if that person making the complaint has named the employer as well, which from a strategic perspective, again, because we work for employees and employers, if you're an employee, you want to go for the person who's got the biggest pockets. Who's that likely to be? Little Johnny or the big multinational company? It's likely the company. So it's very unlikely from a strategic perspective that an employee would just go after an individual and not go after the employer. But that's often why in these circumstances, we do recommend, depending on how the matter is going, that the employer gets its own legal representation, and that if there are specific named employees, they should get their own lawyers as well, because it won't necessarily, you're not expected to take the fall for your employee if you're a business, and you should get separate legal advice in that circumstance.
Is there a statute of limitations? That's a very legal question. I don't really know.
All good. I can answer that one. So yes, that is the what we talked about in those slides a bit earlier back, which are also, I think, in the fact sheet as well. So for example, if it is a sexual harassment complaint that involves a termination, the employee has 21 days to make that kind of complaint. If it's a stop sexual harassment order from the Fair Work Commission, the employee making that complaint has to still be employed. So that is the limitation there. They can't, if they get fired, then they can't make an order to stop sexual harassment because they're not there anymore. If it's a complaint to the Australian Human Rights Commission, you got 24 months from the last event that occurred. And so that is, again, regardless of whether you're an employee or not at the time you make the complaint, as long as you're within that 24 months. And the Commission does have the power to allow out-of-time applications as well. We had a disability claim recently, which they allowed an out-of-time application, and also a sexual harassment matter as well, which was significantly out of time. So the Commission will sometimes bend the rules a little bit there and have the power to do that. And then most of these state jurisdictions, it's 12 months, but equally they also have room to make an application out of time. So there's limits on paper, but they can potentially be quite long. It's a long time to wait, checking the mailbox every day to see if you've been served a legal document.
And a relevant one as we head into sort of the end of year and parties and things, what systems, processes can you put in place for a large party with 300 people or more in a venue with alcohol served, if you want to be a responsible employer taking proactive steps to protect your employees?
Yeah, look, it's always the challenge, but running these kind of briefing sessions beforehand is going to be really helpful. Checking that you've got a policy in place is going to be helpful, and refreshing people on that. So if something happens, they know who to talk to. Doing things like considering, your RSAs and responsive serves of alcohol, whether that means reducing people's, like the bar tab or whatever it is, or making people have to drink a glass of water between each time they go to the bar, those kind of things. Some interesting kind of novel ideas we've seen or heard about from other clients is things like paying for people, prepaying for transport home for people, so that way, as soon as the event's over, everyone goes home and you don't have lots of people going and doing kick-ons and that kind of thing, which can get a bit out of hand, because the Commission has frequently found, and the courts have found, that, kick-ons from the Christmas party will still be the employer's fault, because again, the only reason there's kick-ons is because there was an employer function event beforehand. So it's challenging, but it's all about communication with people, setting up the systems to reduce the likelihood, and then if something does happen, acting on it as swiftly and as appropriately as possible.
Yeah. What happens if you observe an incident where your employee is clearly being harassed by a client's employee? We love the client agency power dynamic, but the employee is adamant that they don't want to take it any further, even if you're offering full support. Is there still risk in that situation?
Look, yeah, there can be. I think if it is known, for example, that there's a particular client who's a returning client who is this way, who is inappropriate towards people, I imagine that would be, by a good lawyer, be able to be put underneath a hostile work environment, particularly if it's well known in the business that, this client's got, the person we have to speak to, the instructor, he's always being sleazy and touching people. That's going to be creating potentially a hostile work environment. So I think there's still some liability there. But I guess the other thing is that because of that positive duty to protect people, I think even if that employee in particular is saying that they're fine with it and doesn't bother them, you've always got that risk that, you know, they're going to leave and it's going to be reassigned to another employee, and you knowing that this person has a reputation, or this client, sorry, has a reputation for doing the wrong thing, is going to be a problem, because just because this employee isn't complaining, it doesn't mean the next one won't. So it's very difficult. We are currently dealing with a matter where there has been a referrer, actually, so not a client or anything like that, but a referrer at a company function, and there was an incident, and the employer now is potentially looking at having to close their entire office in that state, because the person who was accused was running and managing that office. And if they have to terminate them because of sexual harassment, an interaction between, again, not even an employee or a client, it's going to make a huge, massive hole in their business. So I can appreciate it's really challenging, but the way the legislation is going and the way the Human Rights Commission is acting is that if you see something, you really have to do something about it, even if the people involved don't feel like they can say anything, or are saying they don't want you to do anything, as Hannah said, potentially because they're concerned about their reputation or their career or something like that.
Yeah, it's a tricky one, but I do think with that very explicit accessorial liability, it's a little bit naive to say, oh, well, if you don't want me to do anything, let's just turn a blind eye. We're almost out of time, but there's one last question, which is just a bit more of a POV, because I know this is quite a complex area, but what's your viewpoint on the use of NDAs when employees kind of settle with their employer after a sexual harassment case and leave the company? We do have a fact sheet on this in the Create Safe Space toolkit as well, just FYI, but it'd be great to get your point of view on this, Dimitrious.
Yeah, look, this is absolutely a bit of a personal opinion thing. I know, for example, Danny actually wrote an article for the Sydney Morning Herald about this, and her view was that it's important to give people the option to have NDAs, because sometimes, you know, people don't want their stories to be out there, and they don't want to be the poster child for the change, because it's quite traumatic to be that person. And sometimes, you know, if that's going to mean that person gets more money so they can get counseling, it means they can, you know, retrain if they can't go into that industry again, then that's something that's really important. So I think generally there's lots of divergence of views on this, but my personal viewpoint would be, I think it's an important option to give people, because they then can make the choice as to whether they want to be speaking about their experience, or whether other benefits like privacy are going to be more important to them.
Yeah, I think that's in the fact sheet, we talk about that kind of more new school NDAs, where it's a lot more about transparency and giving the choice of how and when to use it to the victim. There's one more here, which I think you did kind of address, but I think it's worth being explicit about. Kick-ons after a work event. So the formal event has actually finished. We've basically left the venue, but there are kick-ons at various venues. Does this end the liability for the employer, or the fact that it was connected to, I guess, a work event? Does the liability continue?
So I think the way that these issues have been managed by the courts previously is that the level of responsibility kind of decreases the further away you get from the actual work event, but I don't think it's never been an off switch. So I think there's absolutely still going to be liability from an employer here. Will it be the same level of liability and the same level of testing, like what was the positive duty in this instance for sexual harassment that occurs in the office versus it occurs in the third kick-ons at 3 o'clock in the morning after the Christmas party? Probably not. But I think it's good to be aware that the liability is not an on or off. It's kind of a sliding scale. And so it's likely that, particularly in these kind of things, there's going to be some liability, but it might be easier for an employer to show that, look, we really did do everything we possibly could to stop this from happening. You can't hang this on us.
Yeah, and I think that goes back to as well whether or not a reasonable person would expect it to be sexual harassment. So if it's a senior member of staff that really should know better, who is the one potentially, what's the word, sexually harassing someone, there's probably a higher level of responsibility there because they should know better, and rather than just kind of, external parties or things like that. I'm wondering whether that might come into the consideration of liability as well, just who's involved.
Yeah, potentially. It is, as I said, these are quite complicated, and a lot of these matters, because of the nature of them, do settle. So the actual ones that have gone all the way to the end in the Commonwealth jurisdiction since the early 2000s, when the Act started, which was in the mid 80s, it's about 24 cases that go all the way to the end. So it's kind of hard, but in those cases, the courts have been very reluctant to let employers off the hook.
So when it doesn't go to we're talking that's end game liability, but when it's settled before court, is there that's much more of just a guided process with lawyers for each trying to reach a conclusion, is it?
Yeah, so we don't have a lot of visibility. Like, you've got no idea, because as was someone previously asked, there's lots of NDAs that are involved, but that's often because a claim, a lawyer writes a letter saying, this is what's happened. If you don't do something about this, my client is going to take you to the Human Rights Commission. You're going to pay $450,000. And the employer just goes, yeah, we don't want to deal with all of that. Here is X amount. Never speak of this again. So a lot of that happens. And unfortunately, we just don't have the numbers on how frequently that's happening to know what people are, deciding is appropriate and what isn't.
Yeah. And just the last one is, can you just recap the 4 departments or the 4 lines of
complaints?
Fair Work, human rights? There were 4 lines that people could pursue.
Yep. So there is Fair Work Commission for a stop sexual harassment order, which is also a stop bullying order. They're the same thing now. There's the Fair Work Commission again for general protections if the person is dismissed because of the sexual harassment complaint being made. There is the Australian Human Rights Commission, which is the third option. And then there is the state human rights commissions. So they have different names in every state.
Great. Perfect. Well, that's we're pretty much out of time. I hope that that's helped everybody to gain clarity on this area, because it is complicated, but and we don't want to be super alarmist, but it's probably best to be completely briefed on kind of worst case scenarios so you can make your plans accordingly. And yes, we will be sending out a fact sheet. There'll be more information available. You can always get in touch with Danny King Legal if you've got further questions. As we mentioned, there's a free 30-minute consult available to ACA members. So hopefully we can really start to stamp this out, both from sort of proactive policy, but also leadership behaviour, reporting mechanisms, and just ongoing training and monitoring. Thank you so much, Dimitrious. Thanks everybody again for coming along. Please let us know if this was useful. Get in touch anytime with Ad Council if you've got any questions. Thank you.